I'm Fred Wagner with the law firm Venable in Washington, D.C., in their environmental practice group, and I've been a practicing environmental lawyer for over 35 years. Well, it's great to be here. I'm talking about the Supreme Court ruling in the Sackett versus the United States case, the Waters in the United States case, that's gotten so much attention, and justifiably so, over the last few weeks. As folks listening to the podcast may know, uh, the debate over what is waters of the United States has been raging for as long as I've been a lawyer. In a way, this whole debate to me is kind of personal because it literally started almost the very year that I graduated. And I've been touching it throughout my entire career on behalf of folks who are trying to apply for permits under Section 404 of the Clean Water Act, on behalf of the government trying to enforce Section 4 of the Clean Water, 404 of the Clean Water Act. And I've even written a Supreme Court amicus brief in the Sackett litigation dealing with this very issue. So I've been working with it for many years, and the reality has been there's been a tremendous lack of clarity and a lack of certainty over the definition of waters in the United States for this whole 35 years. The case Sackett is not the first case that's been in front of the Supreme Court. There's been four chances for the Supreme Court to figure this all out, and they never really have. And the worst case, of course, was the Rapanos case, where the court ruled 4-4-1. They split. They totally split over what the meaning of waters in the United States is, and almost by default, they adopted the Justice Kennedy significant nexus test, which has really been, for the most part, what US EPA and the Army Corps have used for the last decade or so. But it still wasn't very clear, and it got worse because the government tried to regulate based on the Rapanos decision. The Obama administration tried rules. The Trump administration rescinded them. The Trump administration tried rules. The Biden administration rescinded those. Then the Biden administration tried rules. They came out at the very end of last year, literally almost at midnight on December 31st last year. And then, of course, the Supreme Court says, the basis for your rulemaking, we don't agree with that either. So if you've been looking for certainty over the last 3 or 4 decades over the definition of waters in the United States, you've been sorely disappointed. And the most recent Supreme Court case, the Sackett case, the Supreme Court did its best to try to make a more bright line test for what a waters in the United States was going to mean for purposes of enforcing the Clean Water Act. And in most views, they created a much more narrow definition. So whereby the significant nexus test had a lot of concerns related to the technical aspects of a water resource and its relationship to other sources of water in the nearby area, adjacent or not so adjacent, without significant nexus, and that was rejected by all 9 justices of the court. The test is now, is there an indistinguishable difference between the water feature and a traditional navigable water? Think of, wetlands on the coast of Louisiana or wetlands off the Outer Banks of North Carolina, an indistinguishable link between those water features and a river or the ocean or a bay or something like that. Some estimates think that the scope of jurisdictional waters could have been reduced by half. I'm not quite sure that's the case, but there's definitely a consensus that it's a much smaller universe than what would have been regulated over the years. And how that's going to happen, it's still not 100% clear. EPA and the Corps have announced that they're going to engage in a lickety-split rulemaking to react to the Sackett decision, and they say that it's going to come out by September. They say that in public statements. They've said that on the Hill with testimony. That's fast. I mean, the Sackett case just came out in June. For an agency to do a major rulemaking in that time frame, it's almost unheard of. Now, again, they have a lot to work with. They had this major rule that they issued at the end of last year, but the Supreme Court's ruling sort of undercut quite a bit of what they wrote in that rule. So the fact that they've promised to get something out in about 90 days, I'll see it when I believe it, put it that way. But there's a lot of pressure on the agency to get something out to provide some guidance for the entire regulated community to figure out, hey, what about our pending permits? Are our jurisdictional determinations going to change? What about our plans before we submit a permit? Are we going to be doing something different now? So it's dreadfully important that they come out with something. And on top of that, there's been ongoing litigation over the rule, and not all those cases have been resolved. Some of the plaintiffs, some of the people who've been challenging the rule say we're going to continue to fight. Some of the judges have already put the cases on hold because they say, hey, the agency says they're going to come up with a reg. Let's wait and see what they say. But it's inevitable that even that, when it comes out, could be subject to challenge. So, I'm still going strong in my career. I'm not holding out hope that by the time I finish practice, there will be a firm and clear and undisputed definition of waters of the United States. But the Sackett decision, gives more clarity and more guidance than we've had in many, many years. And the implications of it for clean water enforcement, for water pollution management, for the conservation of water resources are pretty severe. So this is all going to shake out over time. We'll start in September. We'll see if the agency gets out its new rule, but there's going to be plenty of other litigation and pretty challenges to boot. So with that, I'll look forward to the discussion with our colleagues.
Continue this conversation with the EcoBite podcast, available wherever you get your podcasts.